My name is Aisha Ahmed bint Azman, and now I will present about the legislative power of the YDPA as vested in Federal Constitution. The articles that lay down the legislative power of the YDPA are Article 44, Article 66 Clause 4A, Article 55, Article 45 Clause 1, and Article 48 Clause 3. Firstly is the Article 44. By virtue of this article, the YDPA is also a part of the legislative body as he is a component of the parliament. Article 45 plus 1 and 2 give power to the YDPA to appoint a certain number of members of the Senate or the Dewan Negara. He will appoint the person who is deemed fit for the position. Article 48 clause 3 granted power on the YDPA to remove disqualification from membership of the parliament. Okay, now we will discuss in detail about the legislative power of YDPA in Article 55. Article 55 of the Federal Constitution stipulates that only YDPA can summon for Parliament to be in session. Secondly, His Majesty also has the absolute power to prorogue or dissolve the Parliament. Therefore, the YDPA is vested by the Constitution to summon for the Parliament to meet within 6 months between the last proceeding in the last session and the date appointed for its first proceeding in the next session. The YDPA can dissolve the Parliament only at the request of the Prime Minister. However, he can withhold his consent to the request. Okay, now we look at Article 66 and it's close to relate with the YDPA legislative power. There are two levels of the legislative body, and the function of them is to draw up, amend, and to pass law that on behalf from the cabinet to the parliament, which give commands and authority from the minister or the empowered party, which are the executive officer. And according to the Article 54 of the FC, the power is from the YDPA, although the YDPA is the head of state, but he is not involved in the lawmaking. Okay. The government bill is introduced into Parliament by the minister responsible for the subject matter. When it has been passed, after debate and voting by the Dewan Rakyat, it is referred to the Dewan Negara where it goes through the same processes. In each Dewan, the bill goes through 4 stages before getting the royal assents, which are the first reading, second reading, committee stage, and third reading. After it has been assented, the act must be published for it to come into force. The publication is done in Warta Kerajaan Malaysia or Federal Gazette. Okay, regarding Article 66 Clause 4, regarding the royal assents, when the bill is passed by both Dewan, it is presented to the YDPA for his assents. The YDPA has no power of veto over such bills as evidenced by the mandatory language of Clause 4 of Article 66. He is required to give his assent within 30 days after a bill has been presented to him. If such assent has not been given up to the time, it becomes law as if he had assented thereto. Means that the YDPA must assent to a bill within 30 days. Otherwise, on expiry of the 30-day period, it becomes law as if he had assented to it. Once the bill is given the royal assent, it becomes an act. The case that we found about the Article 66 Clause 4 is Datuk Sri Anwar Ibrahim and Kerajaan Malaysia and another 2021. In this case, the appellant seeks to challenge the constitutionality of the National Security Council Act 2016 (NSCA). The appellant in his application stated that the act was invalid because it did not receive the consent of the young di-Pertuan Agong. The NSCA had become law by virtue of Article 66 Clause 4A of the Federal Constitution. Under that article, a bill which is not assented to by the Yang di-Pertuan Agong within the time specified under Article 66 Clause 4, which is stipulated as 30 days, shall become law as if it had been assented to. The appellant firstly contended that Article 66 Clause 4A is unconstitutional because the amendment of it offended the basic structure of the FC. Following thereto, the NSCA which became law under that provision is therefore unconstitutional, null and void. In a 5-2 majority decision, the Federal Court ruled that the NSC Act 2016 was valid and constitutional after answering legal questions on the constitutionality of the Act raised by the appellant in relation to the originating suit. Okay. The Federal Court's judge held that the amending acts did not at all serve to remove royal assents, as a bill must still be presented to the YDPA under Article 66 Clause 4 of the FC for the purpose of royal assents. The amending acts only sought to clarify and define the procedure involving the YDPA in the lawmaking process to expedite the passing of laws. The royal assent was not an executive act of the YDPA, but a part of the legislative process, as it came under Chapter 5 of Part 4 of the FC under the heading of Legislative Procedure. This chapter explained the process and steps taken by the legislature in enacting laws. Royal assent was the final step of the legislative process before a bill became law. So it was a part of a legislative act. It was not an executive act that could not be disturbed or dispensed with. The basic structure doctrine was not part of our jurisprudence, but even if for a moment it was assumed that it was, the royal assent was not a feature of such doctrine.
Assalamualaikum. I am Amali, and now we will move on to the next power of YDPA, which is the power to remove, retire, or suspend Superior Court judges. Okay, according to Article 125 Clause 3, if the Prime Minister or the Chief Justice, after consulting the Prime Minister, represents to the YDPA that a judge of the Federal Court ought to be removed on the ground of any breach of any provision of the Code of Ethics prescribed under Clause 3B, or on the ground of inability from infirmity of body or mind or any other cause, properly to discharge the function of his office, the YDPA shall appoint a tribunal in accordance with Clause 4 and refer the representation to it, and may, on the recommendation of the tribunal, remove the judge from office. Thus, in this article allows the Chief Justice, after consulting with the Prime Minister, the power to recommend it to the YDPA to appoint a tribunal to remove a judge from office. Now we will look into the events of 1988 in regards to the Tun Saleh and the judiciary. So here, Tun Saleh Abbas was suspended as the Lord President on May 26, 1988 by the tribunal after he had given instruction that the appeal case on the deregistration of UMNO. Okay, in here, the tribunal concluded that having regard to the views we have already formed upon the material before us, we are of the opinion, in the absence of an explanation being made by or on behalf of Tun Saleh, that he has been guilty of not only misbehaviour but also a misconduct which falls within the ambit of other cause, which render him unfit to discharge properly the functions of his office as Lord President of Malaysia, as set out in Article 125 Clause 3 of the Constitution. Therefore, the Lord President named Tun Saleh Abbas and 5 other Supreme Court judges were suspended. Ultimately, 3 were dismissed and 3 reinstated. Okay, so here, following to this event, Article 125 Clause 3A, 3B, and 3C were inserted to provide for disciplining judges who breach the Code of Ethics.
My name is Nurul Husna Hanisa binti Ahmad Lutfi. My metric number is 1202170. We also explained in the case of Teh Cheng Poh and public prosecutor, where the court said that so when one finds in the constitution itself, or here the question may arise of who may declare the emergency. So the federal power to declare emergency belong to. So, what is the effect of emergency? Once a proclamation of emergency is gazetted, the floodgates are lifted and legislative and